Hi. Welcome to my channel. My name is Mo, and today we're going to be discussing the PLB election petition, right? If you haven't watched the first video I did in this series, it would make a lot of sense for you to watch that video so you can have a little bit more context on some of the stuff I'm going to be mentioning. So now in this video, it's very important to state that I am not going to be talking about the merits of the petition itself. What I'm trying to do with this series is just to explain exactly what is going on, what has been filed, where we are in the process, just so you can follow it as well, right? So I'll really encourage you to watch the first video that I did on this. I'm wearing a jacket only because I'm about to go out, but I really needed to record this video. And this is the second time I'm recording it because the sound was horrible the first time. So cross fingers, sound is great. All right, so let's get into it. I have my computer in front of me as usual, and the reason for that is so I can make reference to the petition itself and also make reference to the law as well. I'm going to try as much as possible to take out a lot of legal jargon, but in the process, I would also explain a couple of things that I think I would need to say often, just so, you can be carried along as well. So are you ready? Yes. Let's get right into it. So here goes. So another thing I also did was that I created this question answer style, which is how I did the last video as well. The reason for this is so that we have very cohesive, submission. See me sounding like I'm in court. Anyways, so we have a more cohesive video. So the first question I have here is, who are the parties, right? So the first petitioner is Peter Gregory Obi, and then the second petitioner is the Labour Party. Now, if you had seen the first video, I did talk about two things when it comes to the parties in an election petition. The first thing is the only people who have locus, which is the right to appear before a court in an election petition in Nigeria as of today under our laws, are people who were candidates in that particular election that is being challenged. And not only were they candidates, they must have also participated in the election. Of course, Peter Obi meets these two criteria. So he is the first petitioner and he's the one bringing, the petition. So he's the first petitioner. Now, the second petitioner is the vehicle upon which he ran, which is the Labour Party, right? Now, also, I mentioned in the first video that Inec is always the first respondent. The respondent, again, is the person who is responding to the petition. And Inec has to be the first respondent because Inec is the one that conducted the election. They have the mandate to organize elections in Nigeria. So they are the first respondents in any election petition. Now, the second respondent has to be the person who was returned as winner. Again, I mentioned this in the first video. And in this instance, the person is Senator Bola Ahmed Tinubu, right? The third respondent in this particular petition is Senator Shettima. And Senator Shettima obviously was Bola Ahmed Tinubu's running mate, so he is the third respondent. The final respondent in this suit is the vehicle upon which Senator Bola Ahmed Tinubu ran and Senator Shettima, right? And that is the APC. You get it? First petitioner, Peter Obi. Second petitioner, the Labour Party. First respondent, Inec. Second respondent, Bola Ahmed Tinubu. The third respondent is Senator Shettima. And then the final respondent is the All Progressive Congress. Is that what they're called? I guess so. Yeah, the APC. Anyway, so what is Peter Obi suing for? Very simple. The beginning of the petition itself states that the agents that were appointed by the petitioners raised complaints about abnormalities in the procedure on election day to the petitioners. Now, I'm going to break down why this is important in a bit. In the first video, I talked about the fact that there are three grounds upon which, that's according to Section 134 of the Electoral Act, there are three grounds upon which an election petition can be brought in Nigeria. The first one is that the respondent was not qualified to stand the election. The second ground is that the election was invalid as a result of corrupt practices and non-compliance with the Electoral Act. And then the third ground is that the person who was returned as winner was not duly elected by majority of the lawful votes cast at the election. Lawful votes cast at the election, I want you to hold that for a bit because we're going to explain why that is important. So all of these three grounds are contained in our Electoral Act, and the petition itself states that these are the grounds upon which the petition is brought. So it kind of covers all of the three grounds. Another thing I also need to state is that the petition that is out there is not the substantive arguments, right? This petition that has been filed, the one that you're seeing in public right now, is just saying that, hey, courts, I have a right to be here, and this is what I want to discuss, right? So it's kind of like a precursor to the arguments that will be made in court. So if you read the election petition in its totality, you would see a lot of places that would say something like, in courts, we would argue this. The petitioner would show X, Y, Z. You know what I mean? Like, so the idea with the petition is not the whole case. This is just stating that I have a reason to be here, and this is why I'm here. So, yeah. Now, we're going to discuss the grounds upon which this election petition is brought, right? The first ground is that the second respondent, Bola Ahmed Tinubu, right? And the third respondent were at the time of the election not qualified to contest the election. Now, I need to talk about something real quick here. There are two prongs to this. The first one is, under Nigerian laws, for you to run as a presidential candidate in an election, you need to have a running mate. You need to nominate a running mate who is going to be your vice president, right? The person is going to occupy the seat of the vice presidency. That is a requirement for you to run the election. And at the time of the election, it would appear that Bola Ahmed Tinubu did not have a valid running mate. How so? Now, another thing also is that in Nigeria, under our laws, right, you cannot contest an election under two constituencies at the same time. Now, what the petitioners are arguing, let me explain the story behind it. So, on July 14th, 2022, Senator Shettima was the senatorial candidate for Borno Central District, I want to say. Yes, Borno Central constituency. And then on the 14th, so before the 14th, right, he was the senatorial candidate for Borno Central constituency. On the 14th of July, he was nominated as the VP candidate for the APC. Now, it wasn't until July 15th that he filed a notice of withdrawal of his senatorial candidacy for Borno Central. Now, under our laws, right, you cannot knowingly hold nominations for more than one constituency. I think it's Section 33 of the Electoral Act. And if that's not correct, I would correct it. Anyway, so you cannot hold nominations for more than one constituency at the same time. So if at the time he was nominated as vice president, as vice president candidate, he already had one nomination pending, then his nomination as VP candidate was not invalid. Now that goes to affect the qualification of Bola Ahmed Tinubu, because it means that at the time of the election, now this is not my argument, this is the petitioner's argument. It means that at the time of the elections, he did not have a valid running mate. So that's number one. I hope that is clear. Now, in the petition itself, the petitioners are arguing that Nigeria constitutes one constituency with regards to the office of the president and vice president, and then senators, and then the senatorial constituency is a separate constituency, and that makes sense. Of course, we have many constituencies in Nigeria on different levels: federal, state, local. Now, the second prong of the disqualification of the second respondents, right? Now, I'm going to be referring to that because, of course, you already understand who I mean by the second respondent. Now, the second respondent, the second round of disqualification that the petitioners are arguing is that he's disqualified because at the time of the election, he was fined $460,000 for an offense involving dishonesty, which is narcotics trafficking in the U.S. And he was fined by a U.S. district court in Illinois. Now, let's go to what our law says, right? Under Section 137, a person shall not be qualified for an election to the office of the president if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or fine, listen closely, for any offense involving dishonesty or fraud by whatever name called, or any other offense imposed on him by any court or tribunal constituted by a competent authority. So it goes on and on, but basically this is what that ground of disqualification is standing on. Now, you can just go by yourself and Google Decree of Forfeiture Case 934483, October 4, 1993, and then you will see the Decree of Forfeiture on there. Now, for usually, right, in the US, and this is not to go into, I guess, analysis of US law, but when an order of forfeiture is given, is usually because the person that has been asked to forfeit something, there is evidence on a balance of probability that the monies were proceeds of a particular crime. So it's usually forfeit those proceeds and don't go to jail, something like that, because, so it's, think about it like a plea bargain of some sort, right? But we're still waiting to see the substance of what actually happened in that particular matter. So I just wanted to give you, just a bit of background as to when forfeiture happens. Now, the second ground I had mentioned is you can also bring an election petition under the grounds of non-compliance with the Electoral Act, right? And, corrupt practices and non-compliance with the Electoral Act. Now, in the petition itself, the petitioner kind of like has different angles that they are coming at this with or through. Anyways, the first one is the general summary of the petitioner's claim is that Inec's regulations and manual are binding on Inec, who's the first respondent, and its staff with respect to the elections. And Inec and its staff did not follow the regulations. I explained this in the first video, kind of like talking about how the Inec regulation talks about the beavers and how the beavers will be used. An election petition, the evidence before us shows that did not happen. So what's the first and second petitioner saying is that Inec is mandated to follow its regulations, and that is for the courts to interpret. The reason why I'm breaking this down is so that when you are listening to the arguments in court and what the judges rule on each issue, it begins to make sense to you and you begin to see how it ties into the substance of the petition itself. Now, the second thing is another ground, let me call this sub-ground, is that the first respondent, right, which is Inec, was mandatorily required to prescribe and deploy the use of technology for the accreditation, verification, confirmation, and authentication of voters contained in Inec regulations. And just like I said, it didn't do that. Then it goes further to break down the process that is stipulated by the regulations by Inec itself. Then he also interestingly talks about the fact that the information of voters was hosted on AWS servers, and that data as of today is still accessible. He also mentioned that that's the petitioners, they can decide to subpoena. Subpoena is to force somebody to come to court to give a testimony. So they can subpoena relevant staff from Amazon to testify to this. They also say that the true data of the election is stored on AWS, and this data should be the same as the data that was uploaded on Inec's IREV. They go further to say that the result sheets that were uploaded to IREV must be the same figures as originated at the polling units. So I guess what they're trying to say here is that there's discrepancies between the figures that originated at the polling units and then the figures that were uploaded on IREV. Another thing it also says is that INEC continued to upload results to IREV even after the announcement of the winner of the presidential elections, right? And this is contrary to INEC's regulations and procedures. In fact, the petition goes to say that at the time this petition was filed, INEC was still uploading results from polling units to IREV as regards the presidential elections. It also goes further to say that petitioners so INEC is supposed to keep certified true copies of all of their electoral documents, right? And then it goes to say that, hey guys, we asked INEC a number of times to give us CTCs of election materials, and they just refused to do that. Another thing he also says is that even the courts, right, issued an order to INEC for us to be given the CTC of election documents in possession of INEC, and INEC still did not oblige. Now, he also says that that due to INEC's refusal to upload to IREV, right, that on the day of elections, that the petitioners' votes were in 18,000 units were suppressed. Suppressed just means what it means. That in Rivers State specifically, right, INEC announced 175K votes for the petitioner and the respondent 231K. But in actual reality, the results were 205K votes for the petitioners and 84K votes for the respondents. And then it goes further to talk about how there was similar suppression in Benue State. Again, this is not me saying it. This is what the petition is saying. Then it goes further to say that votes cast in a polling unit should not be more than the total number of accredited voters, which makes sense, right? People are registered to vote, they are accredited, they vote, and then the votes are counted. But where you have a situation where the votes that were counted are more than the number of voters that were accredited, then it seems like there's something fishy going on, and that's what the petition was trying to say. So specifically, it says that polling units in Ekiti, Rivers, Borno, Oyo, Ondo, Taraba, Osun, Kano, Katsina, Kwara, Gombe, Yobe, Niger states, that the number of votes cast, right, in those places exceeded the number of votes that were accredited on the beavers. It also states that the computation and the declaration of the results in Rivers State, Taraba, Benue, Adamawa, Bauchi, Kaduna, Plateau did not comply with the legitimate process for computation. You know, I had mentioned that here, this is just telling the courts why you're here. The substantive arguments to back up all of these claims in this petition would be made in court. Now, the next thing, I have a meeting, but let me just try and finish this real quick. Now, the next ground is that the second respondent was not duly elected by majority of the votes cast at the election. Again, this argument is kind of like broken down into two prongs. The first one, obviously, if you're saying that, someone was not elected by majority of the votes, it just means exactly what it means, right? They said that the second respondent did not win a majority of the lawful votes that were casted. And then he also talks about the fact that the second respondent did not get up to the required 25 or the purported required 25% in Abuja. I use the word purported because we're still waiting for the law to interpret if getting 25% in Abuja is compulsory or not, right? So that's also another sub-issue that the courts would need to decide that would affect the outcome of the election petition. Now, another thing that the petition is saying is that INEC did not properly compute the votes from the polling units, and that an actual computation would show that the first respondent had majority of the lawful votes cast. Again, some of the things that were going on social media were people saying that Peter Obi is not asking for the mandates. He is asking for the mandates back because he says here that he was the one that had majority of the lawful votes cast in the election if the computation is done properly. It's also saying that during the trial, the petitioner will rely on investigative forensic experts to substantiate its claims. Now, another thing, that's what the petition goes to talk about. Now, another thing I want to talk about real quick is, what are the prayers, right? I explained prayers in my first video, and basically prayers is essentially what you're just asking the court for, right? Why are you here? What do you want the courts to do? The court is not going to go out of its way to grant you stuff that you didn't ask for. Now, one of the things that is very important to mention is that usually you can ask for prayers in the alternatives, and the reason why people do that is to cover all their bases. So if you're reading the election petition, you would see something like in the alternative. So it's just trying to say, give me this, and if you can't give me this, give me that, right? So the prayers, number one, that's what the petitioner is asking the court to do, is to make a declaration that at the time of the election, the second and third respondents were not qualified to contest the election. It's also asking that all the votes cast for the second and third respondents be deemed wasted votes owing to this disqualification. You know, I talked about lawful vote cast, and I said, hold this right there. Now, one of the things that is also in the petition, when you look at it on the face of it, is the arguments, or the proposed arguments, I would say, that since the second and the third respondent were not qualified to contest the election, then all of the votes that were ascribed to them considered wasted votes and invalid. And if that's the case, then the petitioner, then the right computation of the votes cast would mean that the petitioner had the highest number of votes, lawful vote cast. How the petitioners are going to argue this is left to them, right, in court. But I just thought it was a very, very smart move, because it's just a smart move. Let's just leave it there. So now another thing is also asking for, that's the petition itself, that a declaration that on the basis of the remaining votes, that's after counting certain votes as wasted votes, the first petitioner scored a majority of the lawful votes cast in the election and had not less than 25% of the votes cast in each of the states of the Federation and the Federal Capital Territory. So it is the first respondents who met the constitutional requirements to be declared winner of the election. Again, like I mentioned, the court has to really rule on this 25% issue, because the petitioner is the only candidate so far that met that 25% in the FCT. It's also asking for a declaration that the second respondent, having failed to score 25% in each of the states of the at least 25% in each of the states of the Federation and in the FCT, was not qualified to be returned as winner of the elections. And then in the alternative, it's saying that, okay, if you don't grant me this 1, 2, 3 things I've asked for, I want an order cancelling the elections and compelling Inec to conduct a fresh elections where the second, third, and fourth respondents do not participate. Then it goes further to say, in alternative to everything above, if you don't give me anything I asked for here, I want you to declare that the second respondent was not duly elected by majority of the votes cast in the election, did not meet the third requirement, and should not have been returned as winner. I also want you to declare that on the basis of the valid vote cast in the election, the first petitioner, Peter Obi, scored the highest of the vote cast and met the constitutional requirements, so ought to be declared winner of the elections. It is very clear here that in the prayers of the Labour Party petition, Peter Obi is asking to be declared winner of the elections. It is very clear. Make no mistake. That the certificate that the court should make a declaration that the certificate of return wrongly issued to the second respondent is null and void and should be set aside. Then it goes further to say again that if you don't grant me any of these things I've asked for, right? Like, so this is like a buffet here. We have all these different things. I want this. a declaration that the presidential elections is void on the grounds that it was not conducted substantially in accordance with the Electoral Act and the Constitution of the Federal Republic of Nigeria, an order cancelling the presidential elections conducted and mandating the first respondent to conduct fresh elections for the office of the president of Nigeria. So again, here, there are different things that are being asked for, and they're being done in like different combinations. And usually you see this in election petitions, and even generally in different cases, because people are trying to cover their bases as much as possible. Now, another question I have here is, why was Peter Obi's petition cheaper than PDP's petition? He paid 5,430, while PDP paid 12,430. Usually you pay, and litigation lawyers, you can correct me, Nigerian litigation lawyers, you can correct me if I'm wrong in the comments, but usually when you file petitions or any matter in the court, you have to pay something called filing fees, and those filing fees are typically assessed by the type of documents you're filing, how many pages it is, and typically. So the PDP petition that I saw was around 200 and something pages, and then the LP one that I saw was around like 99 pages or so, something like that, or maybe about 100. So maybe I believe that is what caused the discrepancy in the figures. So how long would the case last? Now, according to Section 132 of our Electoral Act, the petition must be filed within 21 days after the date of the declaration of the results of the election, which was done in this case. And then the tribunal has to release a judgment in writing within 180 days from the date of filing the petition. Now, 180 days would mean that, because they have 180 days, so a lot of people have been asking that, does it mean that a swearing in would happen, before the case is decided? That is likely, right? That is likely. Another thing I should also state is that this petition, the court of first instance, just like I mentioned in the first video, is the court of appeal, right? So this will still go to the Supreme Court, or this might, depending on the outcome at the court of appeal, it would go to the Supreme Court, and then the Supreme Court would still adjudicate on this. So obviously, this means that there is a high probability that the 180 days would be extended by a ton. Another question I have here is, can the respondent counter sue? Well, it depends. You're usually counter suing when you have a claim, or when you have a counter claim. Somebody says, "Oh, you did this to me," and you're like, "Yes, you did this to me." Because the respondent is the person that was declared as winner, I don't see what they're going to be counter suing for in an election petition. Maybe they might create another lawsuit that is not an election petition, because obviously, if you are I don't know what they'll be counter suing for, right? Because if you're the winner of the election, But another thing that one thing to state is that depending on the outcome of the elections, of the electoral tribunal at the Court of Appeal, right? Depending on what the Court of Appeal says, the respondent or the petitioner can file an appeal, right? Both of them can file an appeal. And then, because sometimes where it gets interesting is that sometimes the court of first instance would grant what you asked for, but maybe they didn't grant everything that you want, right? So you would appeal that decision even if it's in your favor. So yes, so in that case, so there are cases that happen like that, because you're like, oh, this person won, so why are they still appealing? So that can also happen. So let's say, for instance, at the Court of Appeal stage, the court decides in favor of Peter Obi, right? I couldn't even hide my bias. So the court decides in favor of Peter Obi. So what would happen is that the respondents would appeal, right? If they feel like the courts did not misdirected itself or something like that, then it goes to the appeal. Then in that case, they would now become the appellant's respondents. So it just gets really interesting. But when it gets to the Supreme Court, we'll talk about that later. Now, why is the election petition 100 pages? The reason it's 100 pages is because the petition itself would typically carry affidavits, and affidavits are what I would call witness statement of oath. So basically, when you're watching, all of the legal drama, you'll see people come to courts to give their testimony. In Nigeria, we have something that is called a front-loaded system. And under that system, it just means that you have your statement of oath, it will be written, and then it is front-loaded. All of the parties have what the witnesses are going to say in court. Then on the day of trial, right, in this case, on the day of the argument, you come to court, and then that's the witness comes to court and adopts that witness statement of oath. And then that's when the cross-examination will happen. So instead of the witness coming to court to come and start giving their testimony afresh, that doesn't happen in Nigeria, except in some peculiar cases. But this is front-loaded. So usually when you look at if you look at the election petition itself, after it talks about the grounds upon which the election petition is brought, remember I said that it doesn't have any substantive arguments yet. After it does that, then the written statement of oaths is attached. Now, for this particular petition, we have a written statement by somebody who's a member of the Labour Party. There's one that is by a software engineer, and then there's one that is by a lawyer who's also a voter. So all of these petitions, all of these statements are attached to the petition, and then he just gets bulky. A lot of it is also repetitive, because when you're looking at the petition, it's kind of like emphasizing certain points several times. Now, another question I have here is, has this ever happened before? On the presidential level in Nigeria, I mean, aside Awolowo and Shagari that I talked about earlier, that I talked about in the other video, which you should watch again, by the way, no. We haven't had a situation where a court in Nigeria has overturned the results of a presidential election. But also note that this is the Fourth Republic and our democracy is very, very young, right? So how many civilian presidents have we even had in Nigeria? Our last civilian president coming out of our first civilian president in this republic was Olusegun Obasanjo, right? So, I mean, we're still very, very young. So I still believe that there's always a first time for everything. So that's not even I'm not too concerned about that. But on the state level, what better example to use than Peter Obi himself? Now, in 2003, right, Peter Obi was the governorship candidate for APGA in Anambra State. And then the PDP candidate, Chris Ngige, was declared as winner. Peter Obi said, no. So he went to court. And then after 3 years of litigation he took office in March of 2006. After 3 years of litigation, he won. And then he took office in March of 2006. Now, he was impeached as governor in November of 2006. And the guy went to court again. And then this time, he was reinstated on February 2007. Now, in May of 2007, an election was conducted in Anambra State, gubernatorial elections, right? And Andy Uba was declared winner of that election. And then Peter Obi was like, no, this doesn't make any sense, though, because even if elections are supposed to be held every 4 years, because I only came into office in March of 2006, my time as governor does not expire until March of 2010. And he went to court and he won. So, for me, I think that it's just very, it's just very inspiring to see someone who believes so much in the legal system, regardless of how fraught, with inconsistencies it is, but saying that, I believe it's innate enough to go back over and over again, regardless. So that's why I'm going to try not to be biased here, but let's just leave it on there. I just think that, it is very, very important for us to continue to test our, judicial system, because that's how it becomes stronger. So even Peter Obi historically has made a massive contribution to the, to the development of our judiciary, just by testing it time and time again, to ensure that justice is done. So anyway, so finally, what is the next line of action? The next line of action is substantive arguments are going to be made in court, while the court is going to listen to those arguments, and then, I would also be here to explain as those arguments are being made. So this is the end of the video. Thank you so much for sticking around. I do enjoy doing this series. So if there are any specific things that you want me to say or touch on, please just put it in the comments. And then, don't forget to subscribe. I need to, I need those subscription numbers. But also, like I said, I think it's very important to continue these discussions in the comments. So if there's something that you want me to correct, something that you want me to explain further, something that you want to share, your opinion on something, please put it in the comments. And then thank you for watching. Bye.